Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here today to talk about the appeal that Ms. Jennifer Bongine has filed on behalf of Robert Kelly in the Eastern District of New York. And you guys know, I probably didn't talk about it on my channel, but there had been several extensions, at least 2 extensions on filing this, possibly 3. The last one basically came because her father passed away about a week ago. And so she submitted it. I think the court gave her until Friday to submit. And I could be getting these dates all crisscrossed and confused, but she was given a date in which she had to submit, and I believe she submitted the document, and then they came back and said that there was some errors, and then she had to resubmit again. And so the document was filed and entered on April 18th. And so we are going to, before we start with this, yes, I did get the text messages. Y'all, it was 175 pages of those text messages, and I just did not read through them all, but I have had people reaching out to me on Twitter, reaching out to me on Facebook, reaching out to me on Instagram, just all over the place, wanting to know if I will read the text messages and give my viewpoint. And it kind of makes me feel special that even though other channels have covered those text messages, that you guys still want to hear from your girl. So I will try to make some time to do the text messages as well as preserve my voice, because y'all know the struggle is real when it comes to my voice, and it's even worse now because it's allergy season. So we're going to go ahead and jump into this appeal in the Eastern District of New York. And so it starts with a statement of jurisdiction. And it says that a jury returned a verdict finding defendant guilty of all charges in the government's third superseding indictment on September 27th, 2021. Defendant was, well, let's stop there because he wasn't found guilty on all charges. They found him not guilty, I thought, when it came to the Sonia chick who was the intern at a radio station who claimed that she met him, I believe at the mall or something. He was getting on the tour bus, and somehow she made it from Utah, Salt Lake City, Utah, all the way to Chicago, child. I don't think he paid for a ticket. But she made her way to Chicago and claimed that she was locked in a room in his studio and some stuff took place, but the jury did not buy it. They said, no, girl, get on out of here with that, because that is not. And I thought it was interesting because her charge was more along the assault angle of everything, and she was the only one who said that they were assaulted. Everybody else, it was, like the Mann Act and what else, but she was actually trying to go with the R word, and the jury was not having that. They did not believe her. So in any event, it says defendant was sentenced to a term of 30 years imprisonment on June 29, 2022. Judgment was entered on June 30th, Okay, wait a minute. This doesn't make any sense. It says defendant was sentenced to a term of 30 years imprisonment on June 29, 2022, and judgment was entered on, one day later, June 30th, 2022. Sorry about that. A timely notice of appeal was filed on July 22nd, 2022, After a subsequent restitution hearing held on September 28, 2022, the district court entered a restitution order on November 8th, 2022. Defendant filed an amended notice of appeal on November 22nd, 2022. An amended judgment was entered on December 7th, 2022. On September 9th, 2022, the district court judge entered an order directing the Bureau of Prisons to turn over monies it seized from defendants' inmate trust account to the clerk of the court. Defendant filed a notice of appeal from that order on September 9th, 2022. The United States Court of Appeals for the Second Circuit has jurisdiction over these matters pursuant to 28 United States Code Section 1291, and then there's a note at the bottom of the page that says cites to the district court docket will be as follows: DE, and then the pound sign. Cites to the special appendix will be as follows: SPA, and then the pound sign. Cites to the appendix will be as follows: volume number, and then number of, and then the pound sign. Then they have an A and the pound sign. So this is really irrelevant to you guys listening. It's more for the person that is reading this to know what these different codes are. So then she moves on to issues presented for review. 1. Whether the government failed to prove defendant guilty of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose, and where the defendant and the alleged enterprise were indistinct. 2. Whether the government failed to prove defendant guilty of violating the Mann Act as to who was Jane? That was Ariel. 3. Whether the government failed to prove defendant guilty of violating the Mann Act as to Faith. And 4. Whether New York Public Health Law Section 2307 is unconstitutionally vague, such that defendant's Mann Act convictions predicated on that law must be vacated. 5. Whether defendant's Mann Act convictions predicated on a violation of California Health and Safety Code Section 12290 must be vacated because the government charged defendant with a repealed version of the statute that was unconstitutionally vague. 6. Whether the government failed to prove defendant guilty of forced labor of Geronda and Faith based on an isolated sex act that did not constitute labor of service and that neither victim alleged was forced. Okay, now 7. Whether defendant was denied a fair and impartial jury where 4 of the seated jurors admitted that they prejudged the defendant's guilt and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify the patently unqualified jurors or otherwise conduct a meaningful voir dire of prospective jurors. 8. Whether defendant was denied a fair trial where the government swamped the jury with excessive other bad act evidence, including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activities, his history of transmitting herpes to his sex partners, his abusive behavior towards his girlfriends, and both audio and video recordings of this conduct with women and men, some of whom never testified. Now, I'm glad she brought that out because I just thought it was so crazy. Because I think the one video was it with Dominique. Dominique was in the video, and then it was something with Lisa Van Allen. And I'm like, wait a minute, they're not even here to testify to give context to what these videos are really about or what was really happening. So why were they even allowed to be a part of the trial? So 9, whether the district court's restitution award for Jane and Stephanie's herpes treatment was unsupported by the government's evidence. Right, because did they bring in some doctor's notes? Did they bring in some prescriptions for the date that they were diagnosed with herpes up until, through the years? How you just going to give people money for something that they didn't even prove that they actually had? And then, even if they do have it, how do you know he was the one that gave it to them? Because for all we know, Stephanie, that was back from 1999. And so if she was diagnosed, maybe she was diagnosed in 2000 and something. How do you know one of her sexual partners between 1999 and when she was actually diagnosed didn't give her the disease? Like, it's just crazy what they allowed during that trial. And let's see. Number 10, whether the district court lacked authority to order the BOP to turn over money seized from the defendant's trust fund account to the clerk of the court for future restitution payments. So next we have the statement of case. The defendant is an internationally renowned recording artist, was charged with leading a racketeer, influenced, and corrupt organization, RICO, enterprise between 1994 and 2018, comprised of individuals whose objective was to promote defendant's music and to recruit women and girls in illegal activity with defendant and to produce porn and CP. And you guys know what I'm talking about. Defendant was separately charged with various Mann Act violations stemming from conduct in 2015 related to Ariel and 2018 related to Faith. After a 6-week jury trial, defendant was convicted of all counts of the third superseding indictment. He was later sentenced to 30 years imprisonment. Through new counsel, defendant filed extensive post-trial motions pursuant to federal rules of criminal procedure 29 and 33 that were denied by the district court in a 103-page memorandum decision and order. Not that Ann Donnelly sat there and typed up 103 pages, and I'm sure I read every last one of them to you guys. But just like on the back end to be like, oh yeah, she was serious, child. She had it out for Mr. Kelly, and she just really thought that she was dotting all her I's and crossing all of her T's with her opinion, okay? And well, we know she didn't write it, but she had them law clerks writing it. So defendant includes a concise statement of the case setting out the facts relevant to the issues raised in this brief, and also refers this court to the district court's detailed factual background presented in the light most favorable to the government contained in its order. So A, pretrial motion. But before we get to that, we have a note at the bottom of this page, and the note says on September 14, 2022, defendant was convicted in the Northern District of Illinois with 3 counts of production of CP and 3 enticement counts. He was acquitted of obstruction of justice, receiving CP, and 2 enticement counts. Defendant was sentenced to 20 years imprisonment, ordered to run concurrent to the sentence in the instant case, with the exception of 1 year, which was ordered to run consecutive. All charges brought by the state of Illinois were subsequently dismissed. Defendant still has 1 pending criminal case in the state of Minnesota. And no matter how many times I tell y'all that Minnesota case is still out there, y'all just keep coming back telling me it is not, that they dropped the case was canceled. And even after the Chicago case was dropped, reporters reached out to Minnesota, and Minnesota kept saying, we haven't made a decision yet. But anyway, let's move on. So we pick back up and it says defendant unsuccessfully moved to dismiss the RICO count pre-trial, arguing that the government failed to sufficiently plead a RICO enterprise. Defendant also moved to dismiss as unconstitutional those Mann Act charges premised on a violation of New York Public Health Law, Section 2307. The district court denied the motion in a written order. On July 23, 2021, the government filed a 55-page motion seeking to admit extensive prior bad act evidence. On July 30th, 2021, defense counsel filed a written objection to the government's motion and filed a supplemental response on August 6, 2021. The district court issued a ruling from the bench, followed by a written order largely granting the government's motion. Throughout trial, defense counsel asked the court to reconsider some of its rulings regarding the admission of other bad act evidence, mostly unsuccessful. And for those of you who are not familiar with my channel, who are just tuning in because this popped up on your feed, I have a whole, actually I turned it into a podcast. YouTube told me to take my playlist on this R. Kelly trial and turn it into a podcast, and that's what I did. So if you want to get caught up on some of the videos that I've done, because on this channel we basically read the documents and then I might interject some little comments or thoughts, but for the most part we are bringing you the actual we are 100% bringing you the actual and factual information as it is presented in the court documents, but I might sprinkle in, a little bit of commentary, but you can follow this case along pretty well from my videos, I think. And I do have some videos that are not in that playlist. So if you're looking through the playlist and you can't find something that I mentioned in here, then go over to my community page, look up videos and scroll that way. And I think that I'm pretty descriptive about what I'm talking about in the title of my videos. And then when I have some more time, I'll add those additional videos to that playlist. And I just thought it was so interesting when I turned the playlist into the podcast, how many people started watching those videos. So I was like, well, thank you, YouTube. And so we will get the full podcast, the full length of videos into that podcast for people that just want to follow along at a later date. So moving along, we have jury selection. So jury selection, because of extraordinary pretrial publicity, the district court directed the parties to submit a joint proposed jury questionnaire to be completed by prospective jurors. The parties reviewed the questionnaires to determine whether they could agree to the dismissal of some jurors for cause. The district court conducted an oral voir dire as to the remaining prospective jurors, affording the parties the opportunity to submit additional questions to probe their qualifications to serve as jurors. Numerous seated jurors were either familiar with accusations that defendant had a history of sexually abusing individuals, had previously faced legal problems, and or had seen the highly unflattering docuseries Surviving Lies, in which several government witnesses had appeared. Defense counsel did move to disqualify jurors who admitted they had prejudged defendant's guilt or had gathered knowledge about the case for other sources. And then she lists where all of this information is. And so I have hundreds of pages of copies of documents that she actually submitted along with this appeal. So it's just a whole lot of information, guys. But it's all information that we pretty much already know about if we've been following this case all along. And when I get a moment, I will go through all those documents to see if there's something that I had never seen before and bring that to you guys in a separate video. So C, complainant's testimony. The third superseding indictment charged defendant with various racketeering acts related to sexual misconduct committed against 6 women, inter alia Geronda, who was Jane Doe number 4, and you guys know that's Geronda Pace. Jane, who was Jane Doe number 5, is Azriel Clary. Faith, Jane Doe number 6, is Faith Rogers. And let's see, 1, Geronda. In 2008, Geronda was a super fan, yes, in quotations, super fan of the defendant and met him, in quotations again, because she didn't really meet him. She was walking alongside him as he left court. She told him she was a fan, okay? Okay, there's a note down here at the bottom. It says, Surviving Lies was a Lifetime docuseries that detailed abuse allegations against the defendant. It aired over 3 nights from January 3rd to January 5th, 2019. In its premiere episode, it was Lifetime's highest rated program in more than 2 years with 2 million total viewers. And then that was from Vanity Fair. So then she says, in May 2009, Geronda and her friend received an invitation to a party at defendant's home by one of defendant's employees. But we thought it was his homie that she got the invitation from. Did that come from Ruby Chris? I thought he was the friend. I didn't know he worked for him. But anyway, Geronda spoke with defendant at the party and exchanged phone numbers. She falsely told him she was 19. A few days later, the defendant invited Geronda back to his house where they engaged in, listen, I have always said to you guys that if it was proven that he actually slept with Geronda, I'm just going to throw up, okay? Because that girl disgusts me. She repulses me. She annoys me. She makes my skin crawl. And I don't know why she just agitates my spirit, but she does, okay? And so maybe he told her he did have sex with a child. I don't know. But anyway, according to Miss Geronda, she felt uncomfortable and privately confessed to the defendant that she was actually 16 years old and that defendant told her to continue to tell everyone she was 19. Geronda did not testify that she told anyone other than the defendant that she was 16. Okay, Geronda continued visiting defendant and having sex with him for approximately 8 months. On January 23, 2010, Geronda testified that defendant slapped her and choked her for disrespecting him. Defendant went into the VIP room with Geronda where he instructed her to perform oral on him, which she did. Geronda left defendant's studio after this incident and did not return. Thereafter, she sued the defendant. Okay, so this is all Geronda's testimony. This is not Mr. Kelly admitting that he actually slept with this heifer, okay? Anyway, so then 2, Azriel. So Azriel and her parents attended one of defendant's concerts in Orlando, Florida in April 2015 when Azriel was 17. She claimed that she made eye contact and connected with defendant while he was performing and danced on the stage during the performance. Someone provided Azriel with defendant's phone number after the show. Azriel attempted to call the number but could not reach the defendant. Azriel's mother began texting the defendant pretending to be Azriel over the course of 2 days. Azriel eventually spoke to the defendant and falsely told him she was 18 years of age. Azriel met the defendant at the hotel room in Orlando where they engaged in sexual contact. At one point, the police arrived and Azriel reassured the defendant she was 18. After checking Azriel's identification and confirming that she was 18, the police left. Thereafter, defendant invited Azriel to meet him in Los Angeles where he was performing. With her mother's consent and encouragement, Ariel met defendant in California and traveled with him while he was touring. After his final performance in Stockton, they had sexual intercourse for the first time. Ariel moved to Chicago the summer of 2015 to stay with the defendant, but when the defendant learned she was only 17, he sent her back to Florida. And then there's a note at the bottom that says the age of consent in Illinois is 17. And then she has the actual legal document in the Illinois legislation that states that. And then it picks back up and says, with the consent of her parents, Ariel returned to Chicago to live with the defendant. In September and October 2015, she toured with him again in the state of California. Ariel turned 18 in December of 2015. Ariel and defendant continued a relationship for 5 years. Defendant had other living girlfriends. Ariel characterized the relationship as abusive at times and detailed that defendant had many rules and would punish her and his other girlfriends with spankings if they broke those rules. Number 3, Faith. Faith met the defendant in March 2017 at a concert in San Antonio, Texas, when she was 19 years old. She and her sister were invited to an after party where she met the defendant, and he gave her his phone number. Faith and defendant began texting regularly. Defendant and Faith met each other in person 5 times and had sexual encounters during those occasions. Defendant arranged for Faith to travel to New York on 2 occasions in May and February 2018, where they engaged in sexual activity. Faith also traveled to Los Angeles on 1 occasion in January 2018, where, according to Faith, she saw a gun in his studio that unnerved her. At the defendant's directions, the defendant performed oral on... Okay, wait a damn minute now. Banjin. At the defendant's direction, the defendant performed oral on the defendant. I'm so confused. I think Faith... I can't remember now, guys. Was the Faith performed oral on him, right? Because she said she feared because the gun was in the room or something like that. Okay. Let's see. So we're going to move on to D. And then let's keep in mind that, her father passed away. She had some other stuff going on throughout the whole process of writing this document. And so we're going to give her a pass on some of this stuff that's these typos and whatnot. And like I stated, they did send the document back to her where she needed to do some what do they call it? Pagination or something like that, the way she had the document paged and counted and some other things that she needed to correct. So I'm not sure if this is the final document or if she's working on the final document. So then it says D, defendant's former employees. The government presented testimony from roughly 8 former employees of the defendant. None of these individuals were charged as members of the enterprise. And I'm assuming that they weren't charged behind the scenes. Because, sometimes, like when people turn state's evidence, they'll have an agreement that if you testify, then we won't follow suit with these charges, or they get immunity, or they get a dismissed sentence, that type of thing. So I am assuming that she has not uncovered any of those type of documents on any of these 8 employees. And I know some of y'all are sitting there saying, well, who are the employees? And child, let me try to think. I remember the Tom Arnold guy. I think the Keith Williams, who was like a security guard. Demetrius crazy, but we know they were going to charge him and threatened him if he didn't testify about the Aaliyah situation. And you guys know this. I don't think she's contesting the Aaliyah. So that's a real touchy situation, and we know it was a bunch of bull crap that they even entered it. So who did I say? Demetrius. Then it was the twins, Suzette and Aliazette, or however you pronounce her name, the Mayweather twins. And then on the side note, Azrael had hired this lady who was a Mayweather to be her publicist. And I noticed that she hadn't talked about her in a while. And also, Azrael hasn't been on social media as much since them text messages came out. So anyway, they were still milking the girl, child, giving her promises and not following through. So I'm thinking that this is probably one of their daughters that she had hired to be the publicist. But anyway, so Tom Arnold, Demetrius Smith, Keith Williams, the twins. Then we had the Copeland lady, Cheryl Mack. Who else? The guy that was mad. Remember, he got fired and fined all that money. I can't remember what his name was. I don't know. That's 9 right there. Yeah, those are the ones that I remember. If I forgot somebody, y'all drop it down in the comments. So, I guess she's going to outline who these 8 employees was, because she started with number 1, Demetrius Smith. Demetrius Smith, friend and personal assistant for the defendant from 1984 to 1994. Smith met defendant as a teenager when he was still attending high school and singing in subways in the mid-1980s. Smith was first a friend and mentor to the defendant, and then began working as his personal assistant when defendant received his first record deal in 1988 or 1989. Smith worked off and on for defendant as a personal assistant until around 1994. Smith's responsibilities included assisting the defendant in things he needed and with scheduling. Smith testified that defendant met Aaliyah through his manager, Barry Hankerson, who was Aaliyah's uncle. Smith testified that from his perspective, their relationship was strictly about music and that he never saw defendant take Aaliyah out by herself. Smith did concede there were short periods of time when defendant might be alone with Aaliyah. There were times when he thought defendant and Aaliyah were overly playful or too friendly, and he asked defendant if he was messing with Aaliyah, to which defendant always responded no. Smith raised those concerns a few times, but only learned that the relationship was more than platonic in 1994 when he was believed that Aaliyah might be pregnant. Okay, so I know a few paragraphs ago I said maybe they're not going to include Aaliyah, but here she does include Aaliyah. So my thought process, and this is not criticizing Miss Bonjean in any way, the organization seems to be a little off for me. But I'm sure it makes sense to Miss Bonjean. It's just not flowing for me. And so you guys let me know if it's flowing for you, or do you think she should have mentioned Aaliyah when she mentioned the other people that were involved earlier in this document. But let's carry on. So number 2, Anthony Navarro, and maybe here she's just outlining who these 8 employees. She's not actually contesting the Aaliyah charge, and they are just letting it go, but she's just outlining who these 8 employees were. Maybe that's what's going on here. So I take back what I said. Okay. So, Anthony Navarro worked as a sound engineer in defendant's studio for 2.5 years. Navarro understood it was entry-level position and would include such duties as cleaning, doing food runs, and driving guests around. Navarro testified that numerous people came through the studio, including different girlfriends of the defendant. One of his responsibilities was to drive the girlfriends where they needed to go. He was instructed not to speak with defendant's guests. Navarro explained that defendant's guests were generally required to ask permission if they wanted things or wanted to order food, and they were not permitted to wander the studio or defendant's home unaccompanied. Sometimes these guests would stay at the studio for an extended period of time, but could leave if they wanted to. Navarro did not know the details of why any female guests visited. Oops. Click too many times. Let's get back up here. Okay. Navarro never picked up female guests who appeared to be underage. They appeared to be around his age, in their early 20s. Navarro had never seen defendant engaging in sexual activity in his home or in his studio. Navarro went on tour with the defendant and observed that invites would be distributed to attendees for after parties. Sometimes defendant's phone number would be on the invites. At times, he would see defendant's phone number distributed to people at the mall or at a restaurant. Navarro never saw underage girls backstage. Navarro recalled that identifications were checked before people could go backstage, but he could not recall whether people had to be 18 or 21. 3. Tom Arnold, runner studio manager from 1998 to 2011. Oh, let me go back up because I don't think I read. Anthony Navarro was a runner and sound engineer from 2007 to 2009. Okay, so Tom Arnold, runner studio manager from 1998 to 2011. Tom Arnold worked for defendant from 1998 to 2011. He started as a runner and eventually became his studio manager and road manager. One of Arnold's responsibilities working for defendant was to provide transportation to his guests, which could include men with whom defendant played basketball, a musician, and his female guests. If defendant wanted Arnold to transport a guest somewhere, defendant would tell him directly, or someone with defendant would make the request. Arnold testified that the protocol for driving guests from one location to another was to open the door for them, turn the rearview mirror up, and then turn the radio on to a reasonable volume. Arnold understood that turning the rearview mirror up was to avoid eye contact with defendant's female guests and to ensure their privacy. Guests at the studio were required to sign confidentiality agreements that prohibited guests from recording or taking photographs. Staff would either take Polaroid photos of guests or copy their identification to confirm the identity of the person signing the confidentiality agreements. Okay, somebody just called me. Sorry about that if you heard the phone ringing. Okay, where was I? Or they would take the picture. Guests at the studio. Where? Oh, confidentiality agreements. Okay, the policy of having. You know what, guys? Hold on a second, and let me put my do not disturb on. Hold on. Okay. Okay, the policy of having studio guests sign confidentiality agreements originated with defendant's business manager and lawyer. Arnold generally had no interactions with defendant's female guests. If a guest in the studio was hungry, they would call the front desk and Arnold would arrange to get them food with petty cash that was at the reception area. If a guest wanted to move from one location to the studio to another, Arnold would get permission to escort the guest. If a guest wanted to speak with the defendant, Arnold would relay the message to the defendant. Arnold explained that generally guests would not be able to roam defendant's studio and home freely, but would ask for permission to go from one part of the studio to another. Arnold testified that there were instances when he would provide defendant's phone number to a woman, not normally in a concert setting, but an after party or at a club or possibly at the mall. There were also other members of the entourage who would give women defendant's phone number. Underage people were not permitted backstage, and identifications were checked to ensure that Arnold did not testify that he provided defendant's phone number to any woman underage. Arnold testified that he sometimes arranged travel for defendant's female guests until they began using a professional travel company. Arnold would obtain the guest's identification to arrange their travel. Arnold did not testify that he ever booked travel for an underage female guest. 4. Suzette and Alicette, 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 I don't know, child. Mayweather, personal assistant in 2016. Suzette and Alicette, child, the spelling just don't even make no sense to me. What did we say this was? Is it Alicette? Suzette and Alicette? I don't know. Worked as personal assistants for the defendant. Suzette worked for the defendant between October 2015 and February 2017. Of 17. There was some coding in there. Sorry about that. And then I'm going to call her AZ. Worked for the defendant between late 2015 to June 2016. Their job responsibilities were to tend to anything he needed: running errands, grocery shopping, taking care of laundry, arranging accommodations for guests, female and male, coming into town, and booking airfare. Suzette and her sister testified that the defendant had several live-in girlfriends during this period of time. They testified that the defendant was controlling of his girlfriends, expected them to follow certain rules, dress down in baggy clothes, and suspected he slapped or spanked them previously. On a couple of occasions, the sisters expressed concern amongst themselves about defendant's mistreatment of Ariel. The sisters denied that they took any action at any time to assist defendant in procuring girls or women. Number 5, Diana Copeland, personal assistant, executive assistant, intermittently from 2005 to 2018. Copeland began working for the defendant in 2004 or 2005 as a personal assistant and worked off and on for the defendant until 2018. Her responsibilities were largely household in the beginning, tending to housekeepers and nannies and making sure they were paid. Later on, Copeland would do administrative jobs like answering phones, maintaining defendant's schedule, and tending to defendant's guests, which could be anyone from a record label executive to a personal guest. Copeland would make hotel and travel arrangements for the defendant, his entourage, and his girlfriends. Copeland would sometimes carry defendant's backpack, but she never went through it. She did see an iPad in one of the backpacks once. During her last stint of employment with the defendant, one of Copeland's responsibilities was to help him get control of his finances. Defendant had difficulties reading and writing. He had no control over his bank accounts, did not even know his social security number, and did not know where his royalties were going. Defendant instituted rules for guests on his property, namely to knock before entering a room and not to roam around the property unsupervised. These rules applied to anyone, everyone, and were actually initiated by his wife when she lived on the property. Copeland acknowledged that defendant's girlfriends also followed defendant's rules to wear baggy clothing and not to interact with other men in public. Defendant had girlfriends who stayed at his properties, sometimes for extended periods of time. Some girlfriends lived in defendant's home while others did not. They were free to leave if they wanted to. Copeland never attempted to stop any of defendant's girlfriends from leaving his property. Defendant never asked Copeland to recruit women for him, nor did she ever hear him ask any other employee to recruit women for him. Copeland never saw defendant attempt to prevent any woman from leaving his home. She never saw defendant lock any of his girlfriends in a room, and he never asked for her to confine any of his girlfriends. Defendant's girlfriends had constant access to food and assistance to help them with anything they wanted. 6. Nicholas Williams. I don't remember Nicholas. Williams worked for, and he was an intern and runner in 2003. Nicholas Williams worked for the defendant for a year in 2003 when he was 19 years old. He described the environment as hostile work environment and was disappointed that was not able to use, okay, I think she meant that he was not able to use the audio equipment. I think I do kind of remember him. Is he one of the people that sued for the back wages or something? Or was that the Navarro guy? Anyway, different types of people visited defendant at the studio, ranging from professional artists, musicians, actors with whom he was doing projects, personal trainer, some of his entourage, and female guests. Williams noticed that defendant's female guests at the studio were young. Williams was instructed not to interact with the female guests. 7. Cheryl Mike, executive assistant from 2014 to 2015. And for those of you who don't know, Cheryl Mike is the mother of London on the Tracks, who is a music producer. So Mike, M-A-C-K, I know y'all get mad. Y'all say I be saying Mike, like M-I-K-E, but it's my southern drawl, okay? So anyway, she met defendant in 2005 when she was working as a talent manager in the industry. She reconnected with defendant in 2013 through another record executive and began working as defendant's executive assistant in 2014. She managed defendant's calendar and worked on projects with him. She also arranged travel for his guests and entourage. Cheryl would arrange travel as requested by the defendant and use the company credit card to book necessary reservations. She used a company known as Preferred Travel to make most reservations. She was prohibited from socializing with defendant's guests. Cheryl received a text message from Ariel in April 2015 asking her to book travel arrangements to California for Ariel, which she did. She later met Jane or Ariel in the lobby of the Mandalay Bay Hotel in Las Vegas, where she was checking into her hotel room. She also saw Ariel in Kelly's dressing room at a venue in Connecticut where he was performing. She was there with several other individuals, but eventually she left when Kelly began massaging Ariel's leg because it made her feel uncomfortable. She said she quit the following day. Yeah, right, girl. So then we move on to E, other bad act evidence. And you know, guys, I hope I can get through this at the 1 hour mark, because I don't want to go over an hour on this video. Okay, and there's a whole lot of pages left over. So it'll be a couple of videos that it'll take me to get through this. But it just takes a really long time for the video to download when it exceeds an hour. So E, other bad act evidence. Over the defendant's objections, the district court permitted the government to admit testimony about defendant's uncharged sexual behavior with at least 8 other individuals, including testimony from Javante Cunningham, some chick named Addie, Kate, Alexis, Lewis. Wait a minute. I'm trying to remember who these people were. Angela, we know, was Javante Cunningham. Then there was somebody named Addie. Addie was, and she's going to explain, I'm sure, who these people were, so I don't need to be going back trying to remember. So Addie, Kate, Alexis, Lewis, Alex, and Anna. Lewis, we know, was the guy that tried to bribe Azriel. Ricky LaFleur was his fake name. Why I can't remember that boy's name now. It'll come back to me later. I'll let you, and you guys can put it in the comments because I'm sure y'all remember too. So the district court's order details the testimony of these other bad act witnesses. Let's see, the district court further permitted testimony from numerous witnesses and through medical documents about defendant's history, contracting sexually transmitted diseases, including herpes, and his alleged transmission of herpes to women, other than any complainants. I'm not sure why she got that in parentheses. The district court allowed the introduction of evidence related to defendants' alleged mistreatment of employees, including docking their pay for violating his policies and rules. The district court permitted the jury to hear audio recordings of the defendant alleged verbal and physical assaults of his girlfriends unrelated to the charged offenses. The district court further permitted several video recordings of graphic encounters, including recordings of graphic sexual encounters, including one, sexual conduct between Alex, Dominique, and defendant. So was Alex's nephew, did we determine that he was the one that was referred to as nephew? I think so. Two, defendants spanking a naked Anna, who is Hallie Calhoun, and calling her insulting names. And three, Hallie's spreading feces on her own naked body. Defendant filed a motion for a new trial based inter alia on the court's admission of excessive, cumulative, and highly prejudicial other bad act evidence. The district court denied the motion. So F, a verdict and sentencing. The jury returned a verdict finding defendant guilty on all counts of the indictment. The jury acquitted the defendant of racketeering counts in connection to claims made by Sonia. Okay. On June 29, 2022, the district court sentenced the defendant to a 30-year term of 30 years imprisonment and imposed court fines and costs. The court deferred a ruling on restitution. G, seizure of defendant's trust fund account. On August 4th, 2022, at the government's direction, the Bureau of Prison confiscated $27,824.24 of money from the defendant's trust account. The government then filed a motion with the district court for an order directing the BOP to deposit the funds from the clerk of court. Defendant objected to the seizure and any turnover order on the grounds that the BOP impermissibly confiscated the funds and the government lacked authority to seize the money where no default was entered, no restraining order was in place, and restitution had not even been ordered in the case. The district court allowed the government's motion. H, restitution. The district court conducted a restitution hearing and awarded Azriel $281,168.18 for medication Valtrex to treat genital herpes for the rest of her life. The district court also ordered defendant to pay Stephanie $78,981.72 in restitution, primarily to compensate her for medication to treat genital herpes that Stephanie claimed was transmitted to her by the defendant. Defendant objected to the court's calculation of these amounts, where the government offered no evidence that Azriel and Stephanie were receiving suppressive treatment with Valtrex, the brand name prescription for valacyclovir. I probably jacked that up, and offered no explanation for why compensation should include the monthly cost of Valtrex, which was nearly 40 times more expensive than the generic brand. Defendant's objection was overruled. That's right, because Ann Donnelly, child, she was being a pain. Okay, summary of argument. Judge Posner cautioned that where a statute is broadly worded in order to prevent loopholes from being drilled into it by ingenious lawyers, there is a danger of it being applied to situations absurdly remote from the concerns of the statute's framers. Such is the case where the government misused both the Racketeer Influence and Corruption Organization Statute, RICO, and the Mann Act in a manner never previously conceived or carried out. Galvanized by an influential social movement determined to punish centuries of male misbehavior through symbolic prosecutions of high-profile men, the government brought a RICO prosecution against the defendant that was absurdly remote from the drafter's intent, stretching the liberal construction. I'm sorry, y'all. I need a drink. Stretching the liberal construction clause well beyond the intent of Congress, the government constructed a RICO theory designed not to effectuate the purpose of the RICO statute, but to prosecute the defendant for alleged misdeeds going back decades without pesky statutes of limitations obstacles. In the end, the government failed to prove the offense of racketeering where evidence of a RICO enterprise was non-existent. The government's evidence failed to show a collective of individuals who shared any common purpose other than to promote defendant's music. At best, the government demonstrated that the defendant used unwitting, low-level employees to carry out anodyne task, and I know I mispronounced that arguably facilitated his sexual needs, but who had no knowledge, intent, or objective to promote his illegal sexual activities. Adding, and she has that in parentheses, so she's being sarcastic there. Adding to its long history of celebrity Mann Act prosecutions, the government charged defendant with violating federal law by arranging Ariel and Faith's travel to other states, California and New York, to attend his concerts with the purpose of violating public health laws, namely by exposing them to herpes during sexual intercourse. Neither Ariel nor Faith were actually infected with herpes during those travels, because the government could not, as a matter of law, prove that a significant and motivating factor for defendants' transportation of Ariel and Faith was to expose them with herpes in violation of state public health laws. The convictions cannot be sustained. There are more problems with the government's creative charging approach. For one, the California Public Health Code that the government contends defendant violated, California Health Safety Code, Section 12290, was repealed by the California legislature and was inoperative at the time of defendant's prosecution. Further, both California Health Safety Code, Section 12290 as charged, and New York Public Health Law, Section 2307, which intend to criminalize exposure to communicable diseases, are unconstitutionally vague, where a person of ordinary intelligence would have no notice of what the statutes prohibit. And, as the case so aptly demonstrates, these statutes encourage arbitrary and discriminatory enforcement. Defendant may be the only person in history who has been charged with violating the Federal Mann Act based on alleged misdemeanor infractions of state public health laws. He is decidedly the only person who has been charged with violating these laws without having actually infected the alleged victims with an infectious disease. So I guess she's saying ain't neither one of these heifers got herpes. Okay. I hope y'all can tell that I am losing my voice here. But I'm hoping that I didn't go into uncharted territory and that I should have stopped this before I got into this section. But let's see. The government's problems extend to its forced labor charges, evincing a clear intent to make federal law coextensive with state law. The government charged defendant with violating the forced labor statute because on isolated occasions he quote-unquote instructed or quote-unquote directed Geronda and Faith to perform an act of oral sex on him. Where he isolated sex acts is neither a quote-unquote labor or service, and neither woman testified that defendant forced the sex act. The government failed to prove violation of federal forced labor laws. Sufficiency of the evidence aside, defendant is entitled to a new trial where the record shows that at a minimum 4 of the seated jurors, jurors 3, 4, 5, and 12, were not qualified to serve. 2 of them had watched the inflammatory tabloid docuseries Surviving Lies. Trial counsel's performance was objectively unreasonable when he failed to move to disqualify patently unqualified jurors and failed to conduct any meaningful voir dire or prospective jurors who expressed their prejudgment of the case. Defendant was prejudiced by his counsel's substandard performance, where it resulted in the seating of at least 4 jurors who were actually biased and could not act with impartiality. There is more. Defendant's trial was engulfed by irrelevant and excessive bad character evidence that added little to the jury's assessment of whether defendant committed the charged offenses. Indeed, the 16-week trial was comprised overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, the government smuggled in a mass of repugnant conduct under the guise that the evidence demonstrated the means and methods of a non-existent enterprise. This case was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in the prosecution was nothing more than inadmissible propensity evidence. Because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, much of it unlawful, albeit unpalatable for some, defendant was stripped of the presumption of innocence and denied a fair trial. I'm sorry, I think I said unlawful. Let me read that last sentence again because it wasn't making sense in my head, and I think it was because I said unlawful when it should be lawful. So the sentence is, because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, and then she has a dash and then ends with a dash, much of it lawful, albeit unpalatable for some, and then it picks back up, defendant was stripped of the presumption of innocence and denied a fair trial. Okay, that makes sense. Lastly, the district court abused its discretion in granting Ariel nearly $300,000 in restitution and Stephanie $50,000 for a lifetime supply of Valtrex for herpes treatment, where the government failed to establish that the women were infected with herpes as a result of any of the charged conduct, that either of them are treated with a suppressive regimen of Valtrex and or actually treated with Valtrex rather than the generic version of it, which is a fraction of the cost of Valtrex. The government failed to offer sufficient evidence to justify the exceptional restitution award. In short, the district court abused the purpose of restitution, statue and granted Ariel a windfall reward for costs she has never incurred or will incur, seemingly to punish the defendant. In its final push to punish the defendant, the district court abused its discretion when it ordered the Bureau of Prisons to turn over $27,000 of seized monies from defendant's inmate trust account for use against a future restitution award without any showing that defendant had defaulted or failed to live up to his payment obligations. Defendant's convictions must be reversed, or in the alternative, a new trial must be granted. So guys, I am going to stop there. And when we come back in the next video, we are going to move into her argument. So what I just read to you was her opening, when she's setting the foundation, and then next she is going to move into the argument. So hold tight, watch this video, get caught up, go back and check some other videos to make sure I'm not losing my mind. Okay, but I think I was pretty clear and concise here. And leave your comments below, rate the video, subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.